And in your review of other cases and publications from Scientology, have you seen anywhere where the religiosity of Scientology has changed at all from your 21 years of experience when you were in the organization?
Objection.
No.
That's all I have.
It's now 5:16 p.m. on Friday. By my calculations, you took, 5+ hours, almost 6 hours, I guess, doing some examination. I thought you told us it was going to take 3 hours. In any event, we are going to reserve our cross at this time. This man's testimony is incompetent. It doesn't qualify under Fry, Daubert, Kumho, Rule 702 as admissible or reliable expert testimony. Having heard this and having heard his discovery deposition yesterday completed and on December 21st and 22nd, I believe that this is a sham, that he's not an expert. I believe that we will be able to demonstrate that he has not told the truth, that he has perjured himself about these things that he said concerning as an apostate concerning his alleged experience
There's no cross-examination then today?
Excuse me.
This is not time for speeches.
No, it's exactly that. We are going to move to strike and for sanctions, and this is incredible. We will reschedule his cross as directed by Judge Moody yesterday when he asked us, the defense lawyers, to give him a call at 3, which we did. At that point, he advised us that the doctor did not tell him that Mr. Young was on the imminent verge of death, that he could not tell him that Mr. Young would not survive 30 days, and as a result, Judge Moody said that we, in light of our vociferous objections about, at that point, we hadn't even been given the 9 inches of exhibits. We'd been given inadequate responses to interrogatories. We hadn't been given responsive documents. In light of our vociferous objections about not being prepared or able to prepare, and you had filed a 125-page document with regard to religiosity, and you had not served us with a affidavit on the Sea Org, one of the areas that apparently he was testifying on that he had done before his first deposition in December that was filed in California. In light of all those things, Judge Moody told us that we could reserve our cross, and that we could schedule the cross in the next 3 weeks, and that's what we intend to do, and that's what we want to do. And Mr. Titus, Mr. Poli, and Mr. Haynes, and Mr. Hertzberg will, I assume, confirm the conversation that we had with Judge Moody yesterday. Is that right?
Exactly as stated.
Now, what we want to do is we want to schedule the cross-examination of Mr. Young for the week. I understand you're tied up this coming week, Ken, doing a trial. We want to schedule it for the following week, which is the week of, whatever it is, January 31st.
That's the week that Janice Johnson.
And we're going, you know what? You've set this as an emergency, and you're the ones that have made the representation about Mr. Young, and we want to go forward and complete this after having had an opportunity to prepare, which is what Judge Moody has told us that we can do. And so what we would like to do is schedule it for January 31st, February 1st, or February 1st, February 2nd. I'm going to be out of town on the 3rd and 4th on matters that have to do with my firm that I have no choice on. So that's what we want to schedule now.
I don't have my calendar with me.
Well, we know those dates, or we know those dates are free.
Why don't you call in, or you always from the court?
Those dates are free.
Let's settle it now.
I'm kind of curious as to why I wasn't privy to this conversation.
Well, excuse me, the judge invited us to call him at 3 o'clock. That's what he told us.
Okay. All right.
Yeah, you made your ex parte submission in the morning, and then he told us to find out what he wanted to tell us in the afternoon.
We called him, and his judicial assistant, or his clerk, put us on the phone with Judge Moody, asked to talk to us, and he did. And he said that he would report to us what occurred with the doctor, which is what he did.
And actually, to make it clear, this deposition was supposed to start at 3. We called the judge at 3:10. You were late. We called the judge at 3:10. We called him back at 3:25, which is at the time approximately that we spoke to the judge, or the judge spoke to us more clearly. And you would have been welcome to participate if you'd been on time.
I was certainly available by phone.
Hey, you were supposed to be here. We were expecting
We
you
noticed the
here.
deposition was noticed for 3.
What time did you finally get a hold of him? He's still on the record.
Yes, we're on the record.
Why don't you give us the dates?
So why don't we? So we have an agreement. Now, are you going to be in Tampa on the week
I think
of the
we need to ask
31st?
Mr. Young.
Mr. Young, can you be in Tampa the week of the 31st to conclude this deposition, sir?
What is today? 20th?
Yes, sir.
21st.
The week after next.
So that'd be
back in a week.
1 week from today?
Yeah.
Right.
Well, no, it'd be a week from this coming Monday.
10 days.
A week from this coming Monday, on a Monday?
Well, it can be a Monday or two. It could be a Tuesday. I mean, I just got to be done before Thursday.
And how much time are we talking about?
Well,
We don't know that.
we don't know that.
Well, you always ask me that question.
Well,
Come on, say I don't know that.
well, I didn't realize we were going to get the whole history of Scientology.
No, you got the whole experience of Mr. Young to qualify him
We've got
as
21
as an
years
expert.
worth of facts.
So we'll proceed here on
You want to do it first on Monday?
Let's go off the record. Let me talk to Mr. Young and see what he can tell me.
Let's find a
Well, the
different
judge wanted us to do
Do it
that
now.
You don't like this
because of the
place?
health situation.
Well, it's your cross. You can go anywhere.
Are we still on the record or off?
Yeah, let's go off the record and let me talk to him.
It's 5:21.
Thank you.